an Article III case or controversy. And by that we mean, remember, the kind of matter that courts traditionally tend to, the kind of matter that courts traditionally resolve. Now, what we mean by a case or controversy is a real fight between adverse parties where a resolution of that fight is appropriate by a court. You have to have a plaintiff with a real stake in the outcome in the case, somebody who's hurt and wants relief. The timing has to be right. The questions presented must be those capable of being answered by a court. And in general, you have to have something that's the ordinary stuff of litigation. Now, it's kind of funny, this matter of justiciability, because you know that when the Supreme Court gets hold of a case, when it finally gets hold of a case, the Supreme Court can render an opinion that's very broad and has extraordinary consequences for the entire society. And yet, we allow the court to make these kinds of pronouncements only if the particular matter in front of it involves an actual specific fight between two people or two groups where something actually hangs in the balance. So in that sense, we grant this great power to speak majestically about what the Constitution is and what it means, but it's only within the confines of a matter that is a real fight between real parties. Now, the chief rationale for this, of course, is that our system is based on an adversary system. We're committed to an adversary system. We think, functionally speaking, that an adversary system is best and that it aids courts in giving judgment. It's better to have an actual dispute with each party having a stake and fighting for a position. You get to see the flesh and blood of the dispute, and it also allows the court to tailor what it's going to say, what it needs to say in a particular case. Now, justiciability, case or controversy, really comes down to three kinds of questions. Who is bringing the suit? The question of who, or the question of standing. When is the suit being brought, or the question of ripeness or mootness. And what is being asked of the court? What question is being asked, raising matters of political questions and advisory opinions. We're going to start first by looking at standing. Standing is a very important topic in constitutional law. It's one that you undoubtedly will spend or have spent considerable time on, and it's one probably, maybe undoubtedly, you will be examined on. So we'll look at the general rules of standing and then the very particular specialized rules of standing. We'll talk about the general rule of standing first and then the specialized rules after that. Now, how do we know when somebody can go into court and sue, when they have the proper stake? Well, the general rule of standing is that in order to have a sufficient stake in a case, because we're looking for you to have some interest sufficient to litigate vigorously, it's kind of the legal equivalent of who asked you, what's it to you, why are you bringing this case? In order to have this kind of stake, you really have to have, the court has said, two things. First, you have to have injury in fact. You, the plaintiff, have to have suffered some direct and personal harm. It can't be harm to somebody else. It can't be harm in general. It can't be a generalized grievance. It has to be the plaintiff, him or herself, actually harmed. Second, you also have to satisfy the requirement of causation. And the court has said by causation we mean the plaintiff must show that the defendant is responsible for the harm that's being alleged, that it's fairly traceable to the defendant's actions. And also, as part of this requirement of causation, you have to show that if you get what you're seeking from the court, it'll actually take care of the harm that you're alleging. So, for standing, you need injury in fact and satisfaction of what we call this causal nexus. Let's start with injury in fact. Injury in fact can be satisfied by any kind of conventional injury. You can have physical injuries, of course. You can be seeking damages, money. That's the usual currency of injury that we accept. But it's not limited to that. You can claim environmental harms or aesthetic harms. As long as the harm of whatever character is personal to you and actual and concrete, and you have suffered it, that can count as an injury in fact. To illustrate this, I'll give you a couple of cases where injury in fact is satisfied and where it's not. There's the case of Sierra Club versus Morton. In that case, the Sierra Club wanted to challenge a plan by the federal government to build a recreational facility on federal lands in a pristine wilderness area. But they were denied standing in the case because they didn't say how the club or any of its members would be affected by the building of that recreational facility on federal lands. The case was dismissed for lack of standing. Now what happened in fact is that the Sierra Club refiled its case and added the proper allegations. But the point is, from the initial suit, it wasn't enough to have a generalized interest in a matter. It isn't enough to have a fervent ideological interest in a matter. It's not enough that there's harm out there. It has to be injury personal to you. You have to show how you were affected. Now, contrast that case, the Sierra Club case, with another case, United States versus Scrap. In Scrap, you had a group complaining about an action of the government that they said would produce more garbage and less recyclable material. Now, what the plaintiffs added in their allegations was that the area of the environment that would be degraded by this action of the government was an area where they walked the trails or breathed the air that would be affected. And the court said, perhaps it was its high watermark of standing really, is that that was sufficient injury in fact because they connected themselves to the harms that they identified. Now, injury in fact can also be satisfied when somebody is claiming harm that Congress has recognized by statute. Congress can pass statutes and recognize interests in us, create interest in us, and if these interests are harms, they can amount to injury in fact. For example, Congress passed a Housing Act that was interpreted by the court as recognizing in an individual the right to live in an integrated community. A set of individuals wanted to sue and challenge the practices of real estate agents and banks known as steering, whereby these agents and banks would steer white groups, to white areas and African Americans to African American areas. And what the plaintiff said in that case is that I'm injured by this practice because there's a congressional statute that recognized an interest in me to live in an integrated community. And I'm actually harmed by these steering practices because I'm in the communities that are affected by these steering practices. So Congress can create interests, the injury to which can be injury in fact for standing. But sometimes Congress can go too far with so-called citizen suits, because even with citizen suits, the court has said, Article 3 injury in fact must still be satisfied. Now, to illustrate this, there's a fairly recent case, Lujan versus Defenders of Wildlife. And that case involved the Endangered Species Act. There's a provision in the Endangered Species Act where Congress allows, quote-unquote, any person to bring an action to enforce the statute. And you had this group, the Defenders of Wildlife and others, who wanted to challenge a regulation that was adopted pursuant to the statute that basically said that federal agencies doing projects that could affect endangered species had to consult with the Environmental Protection Agency. But in the same regulation, it made an exception. It said you don't have to consult about any project if it's on the high seas or takes place abroad, say in Egypt or in France. Now, what the Defenders of Wildlife did is they filed suit, saying that that regulation, that exception to the consultation requirement under the regulation, was contrary to what the statute required. And they based their claim of standing to challenge that regulation on the idea that the statute said that any person could sue to enforce the statute. But when the case got to the Supreme Court said there was no standing in that case because the defenders of wildlife and the other plaintiffs